All right, hello, welcome back to uh, our review kit on business law. Okay, so let's continue. So this is an example of a past question on what on negotiable instruments. So it's very simple. A check is a bill of exchange drawn on a bank table on demand. Required. Explain the following: what's a bearer check and what's a cross check. Those are very simple things I've explained. So just to show you that these things actually come out and they are this simple in the exam. Okay. So let's look at employment law. Look at one or two more laws and we'll round up our review. Okay, now employment law is a branch of labor law that deals with the creation, regulation, and formulation of contract of what employment. So that part of the law that deals with what the relationship between employers and employee. Okay, all right. Now it also determines all right and duty incidental to that relationship under the common law and what and statute. Okay. Now what is employment? Now a contract of employment is a voluntary, please note the word voluntary agreement between a master, and the definition of a master is what employer, and a servant called employee, under which the employee for a money consideration or remuneration promises to render services to the world to the employer. So it's simply a contract between an employer and an employee, and what happens? The employee offers services and then the employer pays him regularly for that what service. Now let's go call control test. How do we distinguish a contract of employment different from other contract? Now one test that's been used in distinguishing a contract of service from a contract for service is the control test. So there's a contract for service. Like example, if I have a consultant working for me, that's not a contract of employment. Now, how do we know? It is said that the servant is a person subject to the command of his master in the manner in which he should do his work. So most times, if the employer can to some extent dictate how the work is to be done, then it's a contract of contract of what? A contract of employment is different from contract for service. Like example, if I say a consultant should come and do a work, most time the consultant will be the one that will dictate to a large extent how he does his work. Okay, now but most times this is not enough. We also have another test called organization test. What's that? Now the test was introduced by Lord Denham Emma in McDonald Evans case, where he said one feather which seems to run through the instance is that under a contract of service, a person is employed as part of the business and his work is done as an integral part of the business, whereas under a contract for service, okay, such work, although it's done for the business, is not integrated to it but merely what accessory to. So there's another third organization. So if the person, the contract of service, the man is employed as part of the business, an integral part of the business. For example, I employed someone to be my security or my driver. Do you understand? Full time, and it's a part of the business. That's now. If I also employ someone to regularly come in, probably a company, a consultant, to come in and help me check the state of my vehicles, that's not integral to my business. That's what we call contract for what? For service. Okay. Now, okay, then another test we do is what we call the circumstance of the case test. Under this test, what is to be done in the time whether a contract is one of service or for service is to consider unrelevant and what available factors. Unrelevant and what available factors. Okay. Now, so some of these factors are: one, whether or not the person performing the service is to provide his equipment. So if the company is providing the equipment, of course that's likely a contract of employment. Whether or not he's to hire his own helpers, okay, for contract of employment, the company will hire those that will help him, but for contract for service, the consultant most time will hire those that will work with him. The degree of financial risk he takes, the degree of responsibility for investment and management, and the length of period of employment or the temporary or permanent nature of the job he is employed to do. Now let's look at the case of women in employment contract. Now, although women have the same capacity to enter into employment contract as men, they enjoy some special protection under the Labour Act. Among the implied terms in their favour are: one, entitlement to maternity leave of 6 weeks before and 6 weeks after their delivery on the production of a medical what certificate. So under the employment, that's clearly stated. So women are entitled to what maternity leave of what 6 weeks before. That means 6 weeks is what a month and a half before they give birth, and 6 weeks after. So that's making a total value of 12 weeks. 12 weeks is how many months? 3 months. So that's what that is. But the condition is they have to provide the medical certificate given by a qualified medical what practitioner that they are pregnant and they need that leave. Okay, right now to be given notice of dismissal during their absence on maternity leave. So if they are absent on maternity leave and then they are dismissed, they can sue and get damages from that company. Right now, to be employed on night work or to be employed in underground work in a mine, except those women holding position of management who do not perform manual labor. So for mining, you can employ a woman to be mining in the what? In the night. Okay. Now, let's talk about terms of contract of employment. So that the terms of contract of employment. Now, first thing is what you call probationary period. This is very common in contract of employment. Now, this is usually a period of trial for a new employee, during which the employee takes the opportunity to study him as well as test his skills and what? Suitability for the probationary period is, like most times, of course, we know from it, is always most likely 6 months. Although the law does not dictate when exactly that period should be, but it's a period where you test the employee whether he's actually what? Is actually perform what he said to perform. Due to the transit nature of this period, there are usually stipulations that make the relationship determinable as a what? At a short notice. Then you have what you call duration. Now, the duration of master or servant relationship must be stated if the relationship is to be for a definite time. So if you're employing, there's what we call, if you employ somebody for a fixed term, we call it fixed term contract. For example, I'm employing for 2 years, it must be clearly stated. If it's indefinite, of course, the period will not be stated. The relationship may also be for a particular project, in which case it will be determined upon the conclusion or realizing of the work of the object. Now, let's look at a very core important part of employment contract, which is the duties of what? An employee. One, duties of an employee to his employer include: one, duty to one, obey the employer's lawful orders that are within the terms of the contract of employment and not illegal or contrary to what? Public policy. Okay, so that's that. So one, to obey the employer's lawful orders that are within the terms of the contract of employment and they are not illegal nor contrary to what? Public policy. Okay, that's one. Two, exercise professed skill and diligence, but not to exercise more commitment than he has disclosed to his what? Employer. That's also part of it. Do that for which is employed or other closely related what? Related things. Render personal service and not delegate his duty without the consent of the what? Employer. So he cannot delegate without the employer giving the permission to delegate. Then he has the responsibility to also keep secret confidential information. So information that comes to his notice in the course of his duty, he must not what? He must not disclose it. Okay. Serve the employer faithfully and not to put himself in a situation where his interest will conflict with that of the what? Employer. Now, the remedies available to the employer for a by an employee. So if an employee breaches or does not perform his duty the way it's supposed to do, what are the things or the remedies available under the law to the what? Employer? One, of course, he can dismiss the employee without notice. For example, where the servant has committed an offense, he can dismiss, or another word is sack. Suspend the employee for breach of duty or some default. They can also be suspended. Sue the employee for indemnity. Can also take him to court and try and recover money, in respect of losses incurred as a result of the servant's negligence or what? Or default. Sue the employee in order to enforce reasonable restraint of trade and also terminate the employee's what? Employee's contract. Now, just like employers have their own what? Obligations to duties of employer. Let's look at it. Now, one, to provide work for the servant, especially where the opportunity for work is in the contract of what? Service. That's part of his duty. So ensure that he provides work for the servant or the employee to do. Okay, next, to pay wages or remuneration in legal tender such as check or what? Or transfer and accommodation. So he has a duty to pay the salary of those he has employed. To provide written statements, to provide written statements of the terms of employment within 3 months after the servant has assumed duty. That's letter of what? Letter of employment, or called offer letter, stating what? The terms of the employment, and it must be done within 3 months. Okay. So now, also has a duty to provide a safe system of work, a safe environment. One, provision of proper appliances and plants for the use of the what? Employee. All the equipment that the employee needs to function, the employer has responsibility to provide those things. Okay. Provision of competent staff. Okay, when an employee is injured because of the incompetence of the colleague at work, the employer will be liable to the injured employee, because it is the duty of the employer to employ persons who are sufficiently experienced to work and put them in the what? In the right section. So if you employ a driver that is very that is an employment place driver that is not, he does not know how to drive well, and the driver eats another staff, that staff can sue the employer, because supposed to employ people that are what? Competent. Okay. Then is also to provide a proper system of work and effective what? Supervision. So put a proper system of work in place, and then how is the work to be supervised? Payment of expense reasonably incurred by the servant in the course of his duty. So where the employee spends his own money, right, to carry out duties for the employer, is also the responsibility of the employer to what? To refund or payback. Payment of compensation under Workmen Compensation Act to injured workers or the relative of deceased workers who have suffered mishap in the course of his work or her duties. Granting at least one work-free day per what? Per week. That's also very clear. So you cannot work 7 days a week according to the law. Maximum is what? 6 days. 1 day must always be free. Granting periodic leave with pay to what? Employees. Now let's look at termination of employment contract. Now we have 2 ways. You can be voluntary or what? It can be compulsory. Okay. Now let's look at voluntary. The voluntary reasons for termination include: 1, the employee himself can resign. So resignation by an employee for diverse personal reasons. Then 2, the employee can also retire. That is, he has spent a particular number of years and is retiring from the work. But you can also have what? Involuntary reasons, or reasons that are not voluntary. 1, compulsory winding up of the employer's company. When the company collapses, of course everybody has to go home. That's that. 2, compulsory constitution of the employee during times of hostilities or what? Or war. So if there is war and then they say that there is a mandate that people should join, and then they conscript the worker, that's an example of involuntary what? Termination. Okay. Prolonged illness of the employee. If the employee has been sick for a year or 2 and has not been able to carry out his work, of course that's valid. That's not valid reason to what? To let go. Mutual agreement as when ad hoc job is completed. So if on the initial signing of the contract was agreed that this is going to be like an ad hoc kind of work, when you finish this work is going to be terminated, that will also happen. Termination of the employment by the employer for reasons that include: 1, for misconduct or poor performance of the job. That's also part of it. Death of the what? Death of the employee in case of contract of personal what? Service. So if the employee dies, to that also termination of the what? Of the employment. Next, where the contract of employment is not for a what? For a term setting by the employer. The time the contract in accordance with the terms of the contract. Now, in accordance of cases where an employer can dismiss what? An employee. What are the cases? Now, dismissal is the removal of an employee without formalities by the what? Employer. A master may dismiss a servant, or an employee may dismiss an employer may dismiss an employee for: 1, an act or conduct likely to bring the employer into what? Disrepute. So he has brought the employer, put his name, public name, or the business name in shame. He can, based on that, what? Dismiss the employee. The servant's practice or conduct that exposes the master to loss of public what? Loss of public confidence. Then gross what? Immorality. Those are bases that you can dismiss. Absenteeism without leave or permission, amounting to abandonment of duty. So the person just left for like a week or 2 weeks without giving notice, and then he didn't reach out. That's enough reason to also dismiss the employee. Gross misconduct, which may include what? Insubordination, habitual drunkenness, gross negligence, willful disobedience of lawful orders, and so on. Now, let's look at what we call interdiction. It's different from dismissal. What is interdiction? Interdiction is suspension of the employee pending determination of a criminal charge against what? Against him. So when an employer has misbehaved and then is to be charged, okay, so that's what? Interdiction. So they can just suspend him pending when the investigation will finish. If at the end of the criminal trial the employee is discharged and acquitted of the charge, he will be reinstated to his work. Okay, so let's get this past question. Like I told, this comes out live and direct. An employee may be dismissed for justifiable reason. State 4 grounds upon which an employee may be dismissed. I just listed them now. So you can see that live and direct, that's the way it comes out in the exam. Now, in this same, let's look at admission of estate and trust, and I think we just look at one more and then we finish up our review kit. Okay, so admission of estate and trust. Let's start from will. What is a will? So I find like will. Did you write your will and all those things? Now, a will is a document made by a person referred to as a testator, by which he appoints persons known as executors to manage his what? Estate after his death. So that's what we call it what? A will. It's a document referred to as testator, by which somebody will appoint somebody to manage his what? His estate after his death. That's called will. So after I die, this should go to this, this should go to this. That's an example of a will. And directing the manner in which the estate should be distributed to named beneficiary. Please, A person who died leaving a will is said to have died testate. That's what they call it in the law. Died what? Testate. Okay. A person who makes a will is called a what? A testator. And one name the will to be implemented is called what? An executor or an executrix if it's a male, and if it's a male, it's an executrix. Okay. Now let's look at what we call intestacy. What's that? Now, many persons die without making wills. In fact, that's the more common one you have. It's only very few people that will die and write down will. Who are notwithstanding the advantages of will. A person who dies without leaving a will is said to be what? Intestate. Okay, that's the word. Please, those words can come out in your multiple choice questions. Even if the person dies after writing a supposed will, but the will fails or is declared invalid for any reason, such person is dead to have died what? Intestate. Now, let's have what we call letter of administration when it comes to trust and will and estate and all those things. Now, in order to avoid the squandering of the estate of a deceased person who has died intestate, that is, the person did not the person did not give proper notice, there is a need for his personal representative to procure letter of administration for the purpose of legally and properly administering the intestate estate. Okay. Now, that means that his representative have to give letter of administration for how do they want to administer his estate or properties. Now, letter of administration is a document issued from a court with requisite jurisdiction authorizing specific person or specified persons known as administrators to manage the estate of an intestate person. It is the alternative to a will where there is no will or there has been a failure of a purported will for some reason. So that's what we call letter of. So it's like replacing a will, appointing someone to manage the affairs, okay, or manage the estate, and it's the court that gives that instruction. Now, let's look at different types of letter of administration we have. From the above, there are two types of letter of administration available to estate of a deceased. Now, one is letter without a will and letter with will annexed. Let's look at it now. So letter without a will is that, of course, there's no will, and letter with a will is that the letter is coming with a will on how the property is supposed to be distributed. Now, there's also a third type of letter of administration which may be described as customary letter of administration. These are issued from customary court with requisite jurisdiction, which, for example, Delta, Edo, and Lagos State, instructing or naming somebody to manage the estate. Now, that's what I call administrators or administratives. Now, when a grant is made by virtue of the issuance of letter of administration, the person to whom the administration is granted is known as administrator if he's a man, or administratrix if he's a woman. Okay. Then let's start another word called executor, executrix. What's that now? An executor, executrix is a person appointed in a will by a testator to administer the estate of the testator upon his death in accordance with the instructions contained in the will. It's the person that is appointed by the person that owns the property to manage or to carry out his instructions when he dies. So most times they are always legal practitioners. An executor executive is like an administrator, the personal representative of a deceased person. But while an administratrix is usually appointed by a court, the executor is appointed by the testator or the owner of the will. That's the difference now. Let's look at duties and rights of personal representative now. Personal representatives derive their power to legally administer the estate of deceased person only upon the grant of valid letters of administration or probate to them. So now, before somebody can say you are representing or want to manage the estate of a deceased person, you must have He must have either the letter, like we said, or from or get the other one. Now, guarding and realization of assets. Now, the first duty of a personal representative, whether it's an administrative or executor, is to identify and define the estate by collecting together all the assets and liabilities of the estate. So that's the first thing the person will do, to try and gather all the assets and liability of the estate. In other words, it takes an inventory of all the properties and assets in the estate, as well as his debt and liability. That's the first thing. What are the property he has? Are there people he's owing? Okay, then that's what we call application to court. Now, the personal representatives have a duty to apply to court for an order of court granting them powers to administer the estate of the deceased. Okay, so they will apply to court. That's if it has not been the person did not appoint one, so they will apply to court that want to administer, and then the court will what will give. Then the next step is they now pay the debt and what liability. Now, where the deceased was owing any debt as at the date of his death, the administrator of the estate are under a duty to pay what they must pay such debts. Now, payment of estate tax. Every estate of a deceased person is subject to a tax known as what? Estate tax upon a grant of probate or letters. The estate tax is a form of indirect tax which is imposed on the value of the property comprising the estate of a deceased person, allowing the grant to his personal representative of powers to administer the what estate. So they will pay what we call estate tax. Okay, so please, it's duty of the personal representative to pay this tax, whether it's the executor or the administrator. Now, then let's look at accounts and record. Now, the personal representative of an estate must keep clean and proper record. How was this done? What did he get? How did he sell? Where is the money? And record of the administration. They are also entitled to reimbursement for all necessary and reasonable expenses. So if they spend their money in the process of administering the will, they are supposed to be what? Reimbursed. Okay. Now then, they must not profit. Personal representatives are under a general duty not to profit from the administration of the estate, but we are entitled to reimbursement for all personal funds expended on the estate for the purpose of what? The estate. Now let's look at trust. Now, what's the difference from estate and will? The most acceptable definition of the concept of trust is as provided by Professor Quintot, that trust is the relationship which arises where a person called the trustee is compelled in equity to hold property, whether real or personal, for the benefit of some person. So trust is very simple. Somebody will hand over a particular estate to another person to manage on behalf of what? Someone else. A very simple term is, you have all these rich men do it, all these very rich people, they have trust for their children, so they will appoint managers to manage the trust, and the funds and everything they get from the trust belongs to who? Belongs to the person that is being managed for. Okay, that's what we call a trust. Now, use of trust. Under a trust, two different persons could hold a property. One, the trustee. Trustee is the legal owner, but who does not enjoy the actual benefit of the property. That's that. Then the beneficiary, who is the equitable owner, just the actual benefit of the property. Now, we have different types of trust. Let's look at them. One, there are different types and classification of trust depending on the what? On the author. In the main, however, there are two major types of trust, which are those expressly created, called express trust, and those that came into being by the operation of the law, called what? Implied trust. Okay, so then this can now further be broken down into what? We have private trust and charity or public trust. Private trust, of course, is for what? Is for, let's look at express private trust first. Let's get more details now. There are three essential elements of a trust, that is an express private trust. And these are generally referred to as the three certainties of what? Of trust. And these are: one, certainty of intention, by which the creator of the trust, known as his law, must by the word used by him show a clear intention to create a what? A trust. So if there is going to be an express, that means it's the one that created it. He must what? He must certainly show intention that he wants to create a trust. In showing that clear intention, the word used by the settlor must indicate a positive and unambiguous command that something specific shall be done and a trust shall be created. So it's not something like vague. It must be what? It must be clearly stated. The settlor must not equivocate, and the word used by him must not be what? Precatory. Okay, now. Okay, now for example, an attempt, for instance, to create a trust in which the settlor conveys some of his houses to some persons and the rest of that persons will fail as a trust for failure of the exact subject matter to be taken by the beneficiary. So they must also clearly state what the subject matter is. What is it putting? Property A, property B, property C is to be managed on the behalf of A, B, C. Property X, Y, and Z is to be managed on behalf of K, Y, Z. That's an example of an express trust. The certainty of object, by which the settler clearly identifies the beneficiary under the trust. So for an express private trust to express the what? Beneficiaries must also be clearly stated. It cannot be vague. It cannot be my children. You must name those children. Okay? Alright, now let's get what we call private trust. Now, a private trust is trust created by an individual, either inter vivos, that is, to take effect during the settlor's lifetime, or by will, to take effect after the death of the owner. So we have two types. One, there are some trusts that exist even if when the owner is still alive, they exist. And there are some trusts that they don't what? they exist or they come into effect only after the owner has died. Okay, this is done either inter vivo, so as to take effect during his lifetime, or by will to take effect after his death. They have implied trust. What's implied trust? This is resulting from the presumed intention of the word settlor. Accordingly, most implied trusts are also known as resulting trust, in that, for instance, a trust is created by a settlor, proving property to be held by trustees for the benefit of a person for the life of that particular person, but does not state what happens to the property upon the death of that particular person. The property devolves on the trustee as a resulting trust for the what? For the settlor. In such a case, where the property refers to the settlor in equity, the legal title remains with the trustee, while the equitable title refers to the what? To the settlor. And constructive trust, one which is imposed on the parties by equity regardless of their what? Intention. Okay, all right. Now let's look at there are public trusts. What are public trusts? Look at private trusts. A public trust, in some sense, is the opposite of a private trust. This is because a public trust is mainly charitable by what? By in character. It's more of dedicated towards charity, not necessarily beneficiaries. You have some rich men that will dedicate their properties to what? To what? All these philanthropic activities. That's an example of a public trust. Okay. Now, they are trusts created to benefit the public generally. For a trust to be public or charitable, three essentials are: one, it must be benefit, there must be benefit to the public. Okay, the main intention of a charitable trust must be to benefit the generality of the people or a significant part of the world of that. For instance, the purported trust designed to benefit the descendants of three named family has been held not to be charitable or public. So, of course, if you are just benefiting three families, that's not public. So, that's not a public trust. Then, two, only and exclusively charitable in nature. So, it must strictly be what? Charity. A trust to benefit partly the general public as a charity and partly to non-charitable purposes will fail as a public. So, it must be strictly for what? Charitable purpose. It must not be for anybody's benefit like a private person. Okay. Alright, then it must be charitable in law. Although there is no statutory definition of charity, a charitable trust must be one which must be charitable in the legal sense and not necessarily in the context of just the word charity. Now, a trustee, by virtue of law, what are the things that a trustee can invest in? One, securities created or issued on or behalf of the government of the Federation of Nigeria. So if you set up a trust, they can only invest in that. Two, securities of a state government declared to be security in which a trustee can invest by the President of the Federation of Nigeria. Securities created or issued by companies such as are listed in the schedule to this act, like Nigerian Coal Corporation, Nigerian Port Authority, the Nigerian Railway Corporation. Okay, they can also invest in debenture and fully paid up shares of any company incorporated and registered under what? Under CAMA in Nigeria. So they can invest in shares and debentures too. Okay, then let's look at termination of trust. What are the circumstances where a trust can be terminated? Now, a trust can be brought to an end in four ways. Okay, one, by disclaimer. No one can be compelled to accept the office of a trustee. Okay, accordingly, a person appointed as a trustee may reject the office or decline by appointment, thereby disclaiming the word. So the person they're asking to marry, if he refuses, of course, a trust does not exist. Two, removal. A trustee may also be removed. By which what? By which act the relationship of the trustship is brought to what? Is brought to an end. Okay, all right. Now, three, retirement. A trustee who has accepted the trust office may subsequently wish to be discharged from the office. He can also decide to what? Retire. Then the last scenario is what? If he dies. Let's get a very simple past question. All right. The Trustee Investment Act stipulates securities in which trustees may invest. State three categories of the securities I just mentioned. Like I told you, so business law is quite simple. It comes out exactly like we're seeing it. All right. Thank you.